Good afternoon, ladies and gentlemen. Today Professor Hennings will explain how courts in America decide someone's race.
Yes, Karen. It is a topic that people often find confusing or inconsistent.
I am sure that our viewers are looking forward to it.
To review prior material, most inhabitants of the New World are a mixture of the three colonial populations: Europeans, Africans, and Native Americans. But the United States is unique in preserving a distinct endogamous genetic enclave of mostly African appearance. This leads to conflict between dichotomous myth and genetic reality. The dichotomous myth is that every American is either of the black race or not, with no ambiguity nor middle ground. The genetic reality is that virtually all black Americans carry genetic markers from European colonial ancestors, and about 1/3 of white Americans show detectable genetic markers from African slave ancestors. As with most disputes, this conflict between myth and reality is resolved by the courts. Since colonial times, about 300 appealed court cases have been held to decide an American's race. Why is this necessary? What yardstick do they use? Before the 1955-65 civil rights movement, such trials were held to decide if you could incur slavery's burden of proof, marry, testify, attend school, vote, inherit, commit slander, carry a weapon, or incur carrier liability. Nowadays, the most frequent reason is to determine entitlement, affirmative action, workplace discrimination, residential discrimination, Batson hearings. Throughout the 19th century, courts used three rules to determine race: appearance, whether you looked black; blood fraction, how many black grandparents you had; and association, which community accepted you. Courts then used the one-drop rule from the start of the Jim Crow era to the mid-1980s. But the one-drop rule fell out of fashion in court about 30 years ago, with the Louisiana case of Mrs. Susie Phipps. She was a woman who had considered herself white all her life, as did her husband, relatives, and friends. But when she checked off white on a passport application, the clerk rejected it, saying that she looked like she had a touch of black blood. She sued and lost. She appealed and lost again. According to Louisiana's one-drop rule law, the only defense against an accusation of black blood was to show that you had no African ancestry forever. This is impossible, of course, given that you had 1,000 ancestors 10 generations ago in 1800, and 1,000,000 ancestors 20 generations ago in 1600. She went to the US Supreme Court and lost once and for all. According to the Supreme Court, racial classification was not a federal issue. Since that case, the one-drop rule has never been argued successfully in court. Instead, courts today rely on acceptance by the leaders of the African American ethno-political community. If you are accepted by local black leaders, then you are legally black, no matter what you look like, no matter your documented ancestry, no matter your DNA, no matter your own choice of self-identity. On the other hand, if you are rejected by local black leaders, then you are not legally black, no matter what you look like, no matter your documented ancestry, no matter your DNA, no matter your own choice of self-identity. Here are three cases showing how racial classification works today: Mustafa Hefney, Mary Christine Walker, and twin brothers Philip and Paul Malone. Mustafa Hefney was a businessman in Detroit. He was an immigrant from Africa, from Egypt in fact. And he was working towards naturalization as US citizen. He heard that the Federal Small Business Administration was granting loans to black-owned businesses. He applied. But he was turned down on the grounds that he was not black. The Small Business Administration's explanation, according to the Detroit office, is that black loans are intended only for those whose ancestors suffered under slavery and the Jim Crow era. They said that Hefney could not simply waltz in from Africa and claim to be black. Hefney demanded a formal hearing and lost. The excuse changed during the hearing, however. The court ruled that federal regulations forbid immigrants from North African nations, including Egypt, from calling themselves black, no matter what they look like. Here are the actual regulations. They were interpreted, in Hefner's case, as accepting as black anyone of sub-Saharan phenotype from France or Germany, but insisting that, if you are from North Africa, then you are white by definition. Obviously this makes no sense at all. So one must read the testimony presented at Hefner's hearing, to learn what was the real problem with his application. As it turns out, a parade of witnesses from Detroit's African American community had testified that he lived in a white suburb, was a member of white social clubs, went to a white church, and sent his kids to a white school. He had no contact with the African American community. The hearing judge essentially ruled that racial membership comes down to membership in a community, and that mere physical traits are not decisive. Now let us examine the case of Mary Christine Walker, a 39-year-old Denver school teacher with fair complexion, green eyes, and light brown hair. In 1988 she claimed on a job application to be black. Her prospective employer obtained Ms. Walker's birth certificate, found her listed there as white, and accused her of lying to take advantage of minority hiring policies. The school, UC, had announced that they would consider only black applicants. Walker promptly filed suit in state district court. Walker was born a white child into a white family, but in adolescence she found herself more at home among African Americans. She joined a black church and black social clubs. Her friends and boyfriends were black. She claimed to be black, despite her looks. She sued and won. The school board appealed, and she won again, this time with increased damages levied against the school. The Colorado Supreme Court was apparently persuaded by the large number of influential black leaders, politicians, ministers, etc., who came to testify that Mary was truly a member of the African American community. On September 6, 1989, Judge John Brooks Jr. also ordered the State Department of Vital Statistics to issue the woman a new birth certificate listing her as racially black. Finally, let's consider the case of the Malone brothers. The case of the Malones of Boston went the other way. Twin brothers Philip and Paul Malone applied to become Boston firefighters in 1975, but were rejected due to low civil service test scores. After the city instituted an affirmative action program that added test points for blacks, the Malone brothers claimed that their mother suddenly revealed that her great-grandmother was black. They thereupon reapplied as blacks in 1977 and successfully completed the examination due to the extra points that they received for their newly discovered blackness. For 10 years, they led successful careers and their names were submitted to the Boston Fire Commission for promotion to lieutenants in 1987. Both men passed the qualifying examinations with exceptional scores, without affirmative action points. Then, a fire commissioner who had been reviewing promotion paperwork observed the Malones and accused the brothers of racial fraud. The accusation sparked a political firestorm. One minority leader claimed that as many as 60 of Boston's 351 black and 51 Hispanic firefighters were actually lying whites. Another complained that the authorities had looked the other way for 10 years. If a black person came waltzing into the fire department in the 70s, and it was in his interest to claim he was white, I have no doubt the Boston Fire Department would say, "Wait a minute, you're not white." But, when a white person said he is black, they looked the other way. Stung by the attacks, Boston's enraged Mayor Flynn ordered investigations into all city departments, fire, police, schools to root out other whites who may have fraudulently claimed minority status. A frenzy of bureaucratic evil-seeking ensued. The fire department's investigation turned up 11 Spanish surnamed individuals who were accused of not being racially Hispanic enough. 7 were exonerated, 2 resigned under pressure, the other 2 remained under investigation until the firestorm dwindled away. 2 departments, police and schools, refused to participate in the widening hunt for racial frauds. The following year, a 23-page ruling by Justice Herbert Wilkins of the state Supreme Judicial Court convicted the Malones of fraud and upheld their expulsion. His decision referred to the position taken by the black political leadership. Had the black community supported the Malone brothers, and presumably the disgraced Hispanic firefighters as well, they would have been allowed to keep their jobs. To recap, Mosfefa Hefni was ruled to be legally white, despite being an African of African appearance. Mary Christine Walker was ruled to be legally black, despite having no documented African ancestry. And the Malone brothers' ancestry was never investigated, being seen as irrelevant to their racial classification. In conclusion, US courts today apparently see race as resembling membership in a club or society. If the leaders of that society accept you, then you are a member. If they reject you, then you are not a member. Of America's 3 historical rules of racial determination, appearance, blood fraction, and association, only the 3rd survives in today's US legal practice. That is the end of my presentation for today. Thank you for listening.
Thank you, Professor. I am not sure that I understand this topic. Why must courts of law decide what race you are in America? You said that there have been hundreds of such cases. Surely, it should be obvious to the eye. Look at us for instance. Anyone can see that I have more visible African ancestry than you do. And so anyone would say, in day-to-day language, that I am black and you are white. Why should courts become involved?
It does seem strange, doesn't it? Well, Karen, there are 2 reasons. The first is the US doctrine that African Americans come in all colors. This means that millions of US citizens consider themselves to be African Americans because they were born into the ethnic community, even though they look European or Hispanic. If US society went only by appearance, then racial determination court cases might not be necessary. The second reason is that since about 1690, North Americans have granted special privileges or imposed special restrictions based on racial classification. Until about 1985 it was usually advantageous to be accepted as white. Since then it has often been advantageous to be seen as black. And so, the notion of invisible blackness, wherein some European-looking people consider themselves black, plus the policy of granting or withholding rights based on race, together make the issue contentious. And in civilized societies, contention must be resolved in the court of law.
Well, ladies and gentlemen, that is all of our time for today. This is Karen Sharp.
And Randolph Hemmings.
Signing off until next time.